Thank you very much. And Judge, I was watching as you introduced your family. Thank you for doing that. It's obvious your family is very important to you, and as they should be. I know my wife and I have been married for 58 years, and our children and our grandchildren are the most important things in our life. And I was pleased to see you and to introduce the family. Now, as a senator, of course, another important part of my life is referring to and representing the people of Vermont. And let me talk to you about some of the things I've been hearing from Vermonters. And you have to understand, in Vermont, Vermonters just walk up to you at the grocery store or coming out of church or whatever, and perfectly happy to express their views. And they're concerned about what the Republicans' Affordable Care Act lawsuit on November 10th would mean for them. Now, do you know how many Americans have obtained insurance through the Affordable Care Act?
I do not.
It's more than 20 million. And do you know how many children under the age of 26 are able to stay on their parents' insurance because of the Affordable Care Act?
I do not.
It's 2.3 million. And do you know how many Americans are covered under the Affordable Care Act's Medicaid expansion?
I do not.
It's a little more than 15 million. And I look at that because I look at the people who called me from Vermont. I think of Alex Johnson. She's a single mother. She's a childhood cancer survivor. She works as a nanny in South Burlington, Vermont. She relies on Medicaid for her doctor's visits, her blood drawings, her other testing, all that done to make sure her leukemia stays in remission. She tells me she stays awake at night worrying about losing Medicaid. Now, if the Republicans are successful in what they're trying to do on November 10th, then Alex and actually 60,600 other Vermonters enrolled in Medicaid expansion are going to be left behind. And you contract COVID-19, that's seen as a pre-existing condition. Do you know approximately how many million Americans have tested positive for the coronavirus and survived?
I do not.
That's more than 7,700,000. Those are people now considered to have a existing condition. And one of the most common pre-existing conditions is diabetes. The CDC estimates that 34 million Americans, that's about 1 in 10 Americans, have diabetes. They show that the ACA's Medicaid expansion is the single most important factor for expanding access to affordable insulin. Leslie, a Vermonter diagnosed with late onset type 1 diabetes at the age of 25. For years, she has depended on Medicaid to keep her alive and out of bankruptcy. Now, President Trump recently claimed that he's made insulin as cheap as water. I wish he had told the truth on that. We all know it's not. Leslie now has insurance to pay for insulin. And without this insurance, do you know how much? Because unlike what the president says, insulin is not as cheap as water. Do you have an idea how much Leslie's out-of-pocket expenses for insulin would increase?
No, I do not.
Thank you. And I wouldn't expect you to. There's no reason why you should, but Leslie's costs would more than triple. It'd go up by $11,215 a year. That's in a state where the per capita income is $33,000. So I'm not suggesting that you're callous or indifferent to the consequences if the Affordable Care Act is overturned. you know that these are real cases, and I think you're a sympathetic person. But I do believe that the president selected you because he wanted somebody with your philosophy, and he had a reason for it. Now, some are going to pretend that it's a mystery, and that's what some of my colleagues have. What a Justice Barrett would do when the Supreme Court takes up the latest attack on the ACA. President Trump has made it crystal clear. He's promised that his nominees would overturn the ACA. It's even in the official Republican Party platform. And when he said of the case to be argued next month, he said, we want to terminate health care under Obamacare, the ACA. And within hours of nominating you, he again repeated his hope that the ACA would be overturned. I know I mentioned my friend, the chairman, Senator Graham, knows the president as well as anyone here. He goes golfing with him. He spends a lot of time with him. And I think Chairman Graham knows that the president would not repeatedly promise the American people that his judges would overturn the ACA if he didn't mean it. And I think Senator Graham would have to agree that the president's confident Judge Barrett would side with him on November 10th. That's not necessarily a question of either one of you, but of course the chairman has an opportunity to respond on his time if he wants. But I think we know the president's confident. There's not been an issue in the last decade that's animated Republicans in Congress more in their zeal to overturn the Affordable Care Act. In fact, I counted up the other day. I was surprised at the answers. You know, Judge Barrett, that Republicans in Congress have voted to repeal or gut the ACA more than 70 times, 70 times in the last 10 years. And when they failed, they turned to the court. Do you know how many Republicans on this committee have joined Amicus briefs urging courts to overturn the ACA in NFIB versus Sebelius and King versus Burwell?
How many Republicans had voted? Was that the question?
No. Do you know how many Republicans in this committee have joined in Amicus briefs urging the courts to overturn the ACA?
I don't. I'm having a little bit of trouble hearing Senator Leahy. Is there a way for the volume to be turned up?
Yes, ma'am.
I am sorry for that.
It's on our end, Senator Leahy. That's okay. You can repeat the question. And
Well, how is it coming through now?
very good.
Very well, thank you.
And as you know, I've stayed away simply because I don't think it is safe for you or anybody else to be there. But my question is, do you know how many times Republicans on the committee you're sitting before have joined amicus briefs urging courts to overturn the Affordable Care Act?
I do not know.
It's at least 9 by my count. In fact, they've already weighed in on the November 10 case. 2 weeks ago, the Senate voted on whether to side with President Trump in Texas versus California. And 11 of the 12 senators on this committee sided with the Trump administration and asked to kill the ACA. Now, I understand that you will not share your views on Texas versus California. I know you look at Judicial Canon 3A6 and you're concerned that commenting may give future litigants that appear before you an indication of which way you would rule. Is that correct?
Yes, that is correct.
Okay. Now, my concern my concern is that you've already given us every indication. Every time you weighed in, it hasn't even been close. You've repeatedly disagreed with Chief Justice Roberts. What you said, you clearly believe the statute is unconstitutional. The president has made very clear he expects you to side with him. And let me tell you another area where he expects you to side with him. He expects you to side with him in an election dispute. He says he needs a ninth justice because he's counting on the court to look at the ballots. He says the election will be rigged. The recusal statute, 28 U.S.C. 455, requires recusal where impartiality might reasonably be questioned. Now, when the president declares he needs his nominee to secure his reelection, and then the nominee is ran through the Senate in record time during the middle of an election, some are going to question that nominee's impartiality. Would you, to protect confidence in both you and the court, would you commit to recuse yourself from any dispute that arises out of the 2020 presidential election?
Senator Leahy, I want to begin by making two very important points, and they have to do with the ACA and with any election dispute that may or may not arise. I have had no conversation with the president or any of his staff on how I might rule in that case. It would be a gross violation of judicial independence for me to make any such commitment or for me to be asked about that case and how I would rule. I also think it would be a complete violation of the independence of the judiciary for anyone to put a justice on the court as a means of obtaining a particular result. And that's why, as I was mentioning, I think to Senator Grassley, that the questionnaire that I fill out for this committee makes clear that I have made no pre-commitments to anyone about how I would decide a case. That's out of respect for Article 3 and its designation of the judiciary as a co-equal and independent branch of government. On the recusal question...
I might say that you gave a similar answer when I talked with you and Mr. Cipollone. I had a question, of course, because one of the members of our of the Judiciary Committee said that he would not support you unless he had a commitment that you would vote that way.
Vote on the election?
On another case, Roe versus Wade. And I understand what you're saying is notwithstanding what a member of this committee said, you have not made that commitment to anybody. Is that correct?
Senator Leahy, let me be clear. I have made no commitment to anyone, not in this Senate, not over at the White House, about how I would decide any case.
Well, and the reason I ask is we also have the question of appearance. Now, Judge Joan Larson of the Sixth Circuit sat next to you during your 2017 hearing. She was confronted with this issue as a judge on the Michigan Supreme Court in 2016. Then President-elect Trump challenged a ballot recount. Judge Larson was on his short list for the Supreme Court at the time. She found that being on the short list was a conflict and it required her recusal. You were also on the short list, and then you were actually chosen. Now he's not the president-elect, he's the president. And then the president makes a similar thing as he did and the Judge Larson looked at. He's counting on you to deliver him the election. Judge Larson said that was a conflict for her and would have to recuse. You do not find his comments a conflict for you, is that correct?
Senator Leahy, I'm not familiar with Judge Larson's decision, but she clearly made it once it was presented to her in the context of an actual case where she had to weigh her obligations under 28 U.S.C. 455. If presented to me, I would, like Judge Larson, apply that statute And I recently read a description by Justice Ginsburg of the process that Supreme Court justices go through in deciding whether to recuse. And it involves not only reading the statute, looking at the precedent, consulting counsel if necessary, but the crucial last step is that while it is always the decision of an individual justice, it always happens after consultation with the full court. So I can't offer an opinion on recusal without short-circuiting that entire process.
Well, I think that what I worry about, and I've said over and over again, that if the courts are politicized, from the Supreme Court down to other courts, and I've argued cases in all levels of our federal courts, I've always assumed the judges are totally impartial no matter what president had nominated them. But this president has not been subtle, and he expects his nominee to side with him in an election dispute. I'm thinking of the credibility of our federal courts, and I hope you would at least consider that. The president said he needs a ninth justice because he's counting on the court to look at the ballots in case he loses, because that if he lost, that meant the Democrats had rigged the election. The recusal statute, as you know as well as anyone, 28 U.S.C. 455 requires a justice recuse herself in any proceeding in which impartiality might reasonably be questioned. Now, whether you like it or not, and I suspect you probably do not, the president has placed both you and the Supreme Court in the worst of positions. And so let me ask you a different type of question. I assume you agree with me that it's critical for Americans to have confidence in the Supreme Court. Is that true?
That is true. And I agree with your earlier statement that the courts should not be politicized.
Thank you. And I voted for an awful lot of Republican and Democratic nominated justices, as I did, of course, for Chief Justice Roberts, because I wanted to keep Supreme Court and other courts out of politics. But when the president repeatedly declares he needs his nominee as a way of securing his reelection, and that nominee is then rammed through the Senate in the middle of that election, well, you can see where the nominee's impartiality might be questioned. So my request is, in protecting confidence in both you and the court, are you able to commit to recuse yourself from disputes that arise out of the 2020 presidential election?
Senator Leahy, I commit to you to fully and faithfully applying the law of recusal, and part of that law is to consider any appearance questions, and I will apply the factors that other justices have before me in determining whether the circumstances require my recusal or not. But I can't offer a legal conclusion right now about the outcome of the decision I would reach.
Which is sort of boilerplate response on recusal. So let me ask you another question. You laid out the case for blocking President Obama's Supreme Court nominee, Judge Merrick Garland, for 10 months during election year. You argued in part that Justice Scalia was the staunchest conservative on the court, and Justice Scalia and I were personal friends. I'd voted for him, and I agree with you on that. You claim that the moderate and eminently qualified Judge Garland would dramatically flip the balance of the court. You said it was not a lateral move. That's your quote. It was not a lateral move. So now you're nominated to replace Justice Ginsburg, perhaps the staunchest champion for civil rights of the court. You claim that philosophy of Justice Scalia is your own. Of course, he was the opposite side of Justice Ginsburg in countless civil rights cases. Would you say that replacing Justice Ginsburg by yourself is not a lateral move, like you urged when you supported the blocking of President Obama's nominee, Judge Garland?
Senator Leahy, I want to be very clear. I think that's not quite what I said in the interview. It was an interview that I gave shortly after Justice Scalia's death. And at that time, both sides of the aisle were arguing that precedent supported their decision. And I said, while I had not done the research myself, my understanding of the statistics was that neither side could claim precedent, that this was a decision that was the political branches to make. And I didn't say which way they should go. I simply said it was the Senate's call. I didn't advocate or publicly support the blockade of Judge Garland's nomination, as you're suggesting.
That's not what I'm suggesting. You said it was a lateral. It would not be a lateral move.
What I was suggesting is that it was unsurprising that there was resistance as a political matter to that nomination because it would change the balance of the court. That's kind of it's just
surprised. I was surprised there was resistance insofar as there's so many, at that time, Republican members of the Judiciary Committee who had stated publicly before the vacancy that they thought Merrick Garland would be a good person to have on the court and somebody who could appeal to both conservatives, liberals, and moderates. But
I have full respect for Judge Garland.
I beg your pardon?
I'm sorry, I missed the first part. Are they right to say, could you repeat the question?
No, it's not a question. I was just saying that we had many members of our committee, a number of Republicans who prior to the vacancy had been saying Merrick Garland would be a good person for President Obama to nominate because he could appeal to moderates, conservatives, and liberals. And then of course, their response was, well, we can't have a nominee confirmed by one party that's in control of the Senate and nominated by a president of another party. Of course, I pointed out I was here when Democrats controlled the Senate and President Reagan nominated Anthony Kennedy. And in an election year, Democrats confirmed him. But let me go to another area. Three-judge panel of the Seventh Circuit struck down three provisions of an Indiana law restricting reproductive rights. The state of Indiana requested en banc review of just one of the provisions, the fetal tissue disposition provision. Court split on whether to review the case, leaving intact the panel decision striking down the law. You joined Judge Easterbrook in his dissent. But then the dissent went out of its way to address a separate provision not before the court, the so-called reason ban. Your dissent called a eugenic statute. Judge Barrett, the issue before your court was a narrow one. Why didn't you limit your dissent to the one issue the state of Indiana was asking you to review?
So we dissenters from that denial of rehearing en banc, first of all, dissented, as you say, on the fetal remains disposition portion, which the Supreme Court wound up summarily reversing the panel. On the eugenics portion of the bill, it is true that the state of Indiana did not seek en banc rehearing on that, but we had many other states enter the case as amici, urging us to take that claim up. And what Judge Easterbrook's dissent did was explain why he actually thought it was an open question, but one best left to the Supreme Court. And we didn't reach any conclusion with respect to it.
Well, and your whatever position you took would not have changed the final decision of the court. Now, in 2006, you signed an open letter that's published in the South Bend Tribune. You, on one side, the advertisement describes the legacy of Roe versus Wade as barbaric. On the other side, what you signed, you stated that you oppose abortion on demand, defend the right to life from fertilization to natural death. And I have certainly voted for some judges to take that position. But while not mentioned in the letter, the organization that led the effort believes that in vitro fertilization, IVF, is equivalent to manslaughter and should be prosecuted. Do you agree with them that IVF is tantamount to manslaughter?
Senator, the statement that I signed, as you said, simply said, I signed it on the way out of church. It was consistent with the views of my church, and it simply said, we support the right to life from conception to natural death. It took no position on IVF.
No, I understand that. And as I said, I voted for judges who take the same position you do. But I'm asking, do you agree with the St. Joseph County Right to Life that sponsored the ad that IVF is tantamount to manslaughter?
Well, Senator, I signed the statement that you and I have just discussed. And you're right that the St. Joseph County Right to Life ran an ad on the next page, but I don't even think the IVF view that you're expressing was on that page. But regardless, I've never expressed a view on it. And for the reasons that I've already stated, I can't take policy positions or express my personal views before the committee. Because my personal views don't have anything to do with how I would decide cases, and I don't want anybody to be unclear about that.
Let me talk about some of the positions you have taken. Before you became a judge, you were paid by the Alliance Defending Freedom, ADF, for 5 lectures. You gave them on originalism at the Blackstone Legal Fellowship. Now, I recall being asked about some of their controversies. Were you aware of ADF's decades-long efforts to recriminalize homosexuality?
I am not aware of those efforts, no.
Okay, one of the reading materials they had for the program that you lectured to several times spoke of that. In fact, they had filed a brief in Lawrence versus Texas in support of state laws punishing private homosexual activity. They celebrated when India restored a law punishing sodomy to 10 years in prison. Now, whether you believe that being gay is right or wrong is irrelevant to me, but my concern is you work with an organization working to criminalize people for loving a person that they are in love with. So that's what worried me.
Did you? I wasn't sure if you wanted me to answer that. Mike's.
Go ahead. Go ahead.
My experience with the Blackstone program at which I spoke was a wonderful one. It gathers, best and brightest Christian law students from around the country. And as you said, I gave a 1-hour lecture on originalism. I didn't read all of the material that the students were given to read. That had nothing to do with my lecture. I enjoyed teaching the students about what my specialty was, which is constitutional law, and nothing about any of my interactions with anyone involved in the Blackstone program were ever indicative of any kind of discrimination on the basis of anything.
Well, as you know, same-sex marriage, for example, and Senator Feinstein mentioned this at the beginning, is legal, certainly legal in my state, has been for some time. Do you feel that should be a crime?
Same-sex marriage?
Yes.
Obergefell clearly says that there is a constitutional right to same-sex marriage.
And do you agree with that, stare decisis?
Well, Senator, for the reasons that I've already said, I'm not going to, as Justice Kagan put it, give a thumbs up or thumbs down to any particular precedent. It's precedent of the Supreme Court that gives same-sex couples the right to marry.
Well, you mentioned Justice Kagan. She once wrote an opinion that it's not enough that 5 justices believe a precedent is wrong. Reversing course demands a special justification over and above the belief that the precedent was wrongly decided. Do you agree with that?
I do agree with that. The doctrine of stare decisis itself requires that.
You, having relied on stare decisis in many of my arguments before courts of appeals, I thank you for your answer. Chief Justice Roberts.
Senator Leahy, I don't mean to interrupt. I know you don't have a clock in front of you, but we're about a little over a minute over. So if
I am sorry, Mr. Chairman, I do not have a clock.
No, I understand. I totally understand.
I appreciate it, and I will look forward to the next round of questioning.